In our first module, we will be discussing the history of water rights, and we'll learn the basics of what defines a water right. We will also talk briefly about how to obtain a water right. As Mormon pioneers first began to settle the valleys of our great state, there soon developed a rich and interesting history of fighting over water. Violent confrontations were rare, but more often than not, there was an unspoken awareness of who could or could not be trusted to take his fair share of water. A local historian from Emery County remembered his mother speaking of a prominent rancher in town, saying he wasn't the kind of man you'd want to have upstream from you, if you know what I mean. These types of fights over water is one aspect that led to the development of Utah water law, so let's take a closer look at what that law is and how it came into being. The development of laws governing water in the western United States was markedly different than in the East. The most important reason for this, of course, was the difference in climate and geography. In the East, precipitation is relatively abundant. Watercourses are numerous and generally close to the areas where water is needed. In most of the West, the opposite is true. Relatively little precipitation means fewer rivers and streams. This increases the necessity to divert water to areas of use. The doctrine of prior appropriation, which is currently used as the foundation of the water right system in every western state, developed in response to these types of arid conditions. This means there are two different theories of law related to water use in the United States: riparian law and the prior appropriation doctrine. The eastern states operate under what is known as riparian law, wherein landowners have the right to use a reasonable amount of water as it crosses their property. This system was influenced by English law and works in regions that have significant amounts of precipitation. All of the western states, however, operate under what is known as the prior appropriation doctrine, also known as first in time, first in right. This system was influenced by Western mining law and is adapted for climates with a scarcity of water. It also requires defining the amount of water one can use. Now let's look at the first appropriators of water in the West, which were Native Americans. Originally, community ditches dug by Native Americans were used to divert or appropriate water in the arid Southwest. Some of these ditches are actually still in use today. Next came the Spanish religious and military outposts. The Spaniards required a stable supply of water. While they sometimes used the canals built by the Native Americans, they also dug their own. Thus, the Spanish and Mexican settlers who established missions, agriculture, pueblos, and military posts were also early appropriators. Among the later Anglo settlers of the West were American pioneers and prospectors, including the Mormon pioneers that settled the Great Salt Lake in 1847. They began using water immediately upon their arrival. They knew from descriptions of the area that precipitation alone would not be enough to raise crops. During the same period that the Mormons were settling the Great Basin, gold was discovered in California. Mining required the diversion of large amounts of water from rivers and streams, and the miners applied the tenets of mining law to water use. The concepts of prior appropriation of water, which developed in the California mining camps, spread to other western states as mineral discoveries throughout the West led California miners to expand their prospecting into the surrounding regions. A basic principle of mining law was that the miner who initially staked the claim, in other words, who was first in time, was protected in the development of the claim against other miners, or, in other words, had the first right to that claim. This practice carried over to the use of water and became not only recognized as tradition, but also protected in the courts of law. Congress took a fundamental step in deference to state and territorial water law with the passage of the Mining Act of 1866. Under this law, Congress affirmed water rights for mining, agriculture, and other uses that have been acquired by private parties on public lands. Under local customs, laws, and court decrees, this result was obtained even though many of these appropriators were trespassers on federal land. The first appropriative water right statute was passed in California in 1872. It allowed the creation of such rights by posting at the point of diversion a document stating the intended amount of water to be diverted under the right, its purpose of use, filing for the right in the county recorder's office where the right was located, and taking the steps necessary to perfect the right, or, in other words, to put the water to beneficial use. The right could be lost due to non-use. The next development was passage of the Desert Land Act in 1877. Congress declared the right to use water in the western United States by claimants under the Act must depend upon bona fide prior appropriation. The U.S. Supreme Court held that the effect of the Desert Land Act was to sever title of the water from the public land. Congress directed the rights to use water be established under state and territorial laws separate from land ownership claims. State governments began to realize that a central administrative system to control appropriative water rights, as well as a centralized office of record-keeping for such rights, would be preferable to the haphazard administration which occurred under the early statutes. Therefore, water right law is most often regulated at a state level rather than a local or federal level. Wyoming was among the first states to enact statutes with a comprehensive set of water laws, which they enacted in 1890, giving a state agency a major role in administrating appropriative water rights. The key features in the Wyoming system were, first, the requirement that an application must be filed with the state before a right could be created. Second, the necessity of ruling on an application by the state agency, including possibly denying a permit where no water was available. And third, the maintenance of a central repository of public records containing applications which had been made. A fundamental tenet of prior appropriation law was that the land and water estates were separate and that water could be removed from its natural location and used beneficially somewhere else. This facilitated the public purpose of making an inhabitable region out of arid lands. There were also preferred uses under traditional appropriative law, which embodied the public sentiment that domestic, municipal, and agricultural uses should be met before water could be put to use for other purposes. The prior appropriation doctrine as enacted in the state of Utah contains some key points. First, water must be diverted and put to beneficial use. Second, to uphold the principle of first in time, first in right, all water rights have a priority date associated with them. And third, a water right can be lost by either abandonment or forfeiture. Abandonment is determined by the intent of the water user and does not require a statutory time period. A water right can be lost by forfeiture if the right is not used for 7 consecutive years and some type of adjudicative action is taken to decree the right has indeed been forfeited. Let's take a little closer look at what first in time, first in right really means. Here is a stream hydrograph with the flow shown as the blue line. There are also 3 priority dates shown as the horizontal lines, representing water rights appropriated on each of those dates. The flow rate of the stream is shown on the y-axis, measured in cubic feet per second, and the day of the year is shown on the x-axis, where you can see we marked the beginning of the irrigation season, which is April 1st, and the end of the irrigation season, which is October 31st. Prior to April 25th, the stream is flowing less than 25 cubic feet per second. At that rate, all first priority water rights would be regulated and reduced proportionally. For instance, if the stream flow was only 12.5 CFS, all first priority water rights would receive only 50% of their right. Once the stream reaches a flow rate of 25 CFS, all first priority water rights would have a full allocation of water. As the stream flow begins to exceed 25 CFS, second priority water rights can begin to take water, but the amount they can take is on a prorated basis until the stream flow reaches 90 CFS. At that flow rate, all second priority rights are able to take their full allocation of water. Above 90 CFS, third priority water rights begin to kick in, again prorated until a flow reaches 160 CFS, whereupon all priority water rights have a full allocation. So here's the question. What about that little bit of water above 160 CFS? Who has the right to use it? Well, in this case, it's unallocated. No water rights have been established to capture this flow, so it is allowed to continue downstream, but as you can see on the graph, this flow only lasts a few days and then it's gone. Now let's shift our attention to the role and history of the state engineer and the Division of Water Rights. Willard Young, who was the son of pioneer prophet Brigham Young, was the first state engineer for Utah. He graduated from West Point in 1875 and was an officer in the Army Corps of Engineers. He was also city engineer for Salt Lake City and was appointed state engineer in 1897. His initial duties were to aid in planning, design, and construction of water storage and commands facilities. However, he only served in this position for 1 year due to the outbreak of the Spanish-American War in 1898. He resigned his position to return to the Army and was the key figure in organizing Utah volunteers. Since that time, Utah has 19 other state engineers, including our current state engineer, Teresa Wilhelmsen. Teresa was appointed in February of 2020 and had worked for the division for more than 2 decades prior to becoming the state engineer. She previously held the positions of Assistant State Engineer over Applications and Records, Regional Engineer at the Utah Lake Jordan River Regional Office, and Adjudication Program Manager. Before joining the division, she worked for the School and Institutional Trust Lands Administration. Teresa is a professional engineer and graduated from the University of Utah with a bachelor's degree in civil engineering. The division also has a deputy state engineer and 5 assistant state engineers over field services, technical services, applications and records, dam safety, and adjudication services. Additionally, there are 7 regional engineers scattered across the state and various other administrative and managerial staff. The state is organized into regions, shown by the different colored areas. Note the legend in the top right identifying the location of the various regional offices within the regions. There are areas being represented by 2-digit numbers. These 2-digit numbers are the first 2 numbers in every water right located in that area. For example, 35 for the Weber River, 57 and 59 for the Jordan River and Salt Lake County, 91 for the Price River, and so on. Where there are no major river systems, such as the West Desert, the boundaries follow geographic features creating drainages. Application numbers differ from water right numbers in that they are assigned to applications sequentially by application type. Application numbers begin with a capital A for applications to appropriate, lowercase a for a change application, the letter D for diligence claims, U for underground water claims, F for fixed-time applications, capital T for temporary appropriations, and lowercase t for temporary change applications. Let's now take a closer look at water law statutes and how water rights in Utah are defined in that law. Utah water right laws were first adopted in 1903. The law required filing an application to appropriate for new uses. The application was then reviewed by the state engineer to determine if it met the criteria set forth in statute. If the criteria was met, the application was approved. If it wasn't, it was rejected. The law did allow for the recognition of water rights established by some other method of appropriation prior to 1903, by filing what's called a diligence claim. The law also recognized all existing water rights established by court decree prior to 1903. However, some uncertainty remained regarding the appropriation of groundwater, and there was still some question as to whether any water rights could be established using riparian law. In 1936, the legislature clarified that all waters in the state are subject to appropriation statutes, and that no claims would be recognized under the riparian doctrine of appropriation. That settled the matter on that point. The legislature also included a provision that use of groundwater prior to 1936 would be recognized by filing an underground water claim, similar in fashion to a diligence claim for surface rights. All new uses of groundwater, however, would be subject to the application and approval process currently in use at that time for surface sources. So let's take a closer look at what the law actually says. Title 73 of Utah Code states that all waters in the state, above or underground, are declared to be property of the public. The right to use the water must be acquired by following the provisions set forth in this statute. Furthermore, the beneficial use of water shall be the basis, measure, and limit of all rights to the use of water. These are the fundamental bedrock principles of water law in Utah. Every water right is further defined by several basic features such as title of ownership stating clearly who owns the right, the priority date of the right established either by application, decree, or diligence claim, the quantity of water to be used, defined as either a flow rate or a volume measurement or both, the point of diversion, whether that be from a surface source or underground source, the nature of use, such as irrigation, domestic, livestock, mining, municipal, etc. The period of use. For example, irrigation often has a period of use defined from April 1st to October 31st each year. A defined place of use. And finally, whether or not there is storage associated with the right, such as a reservoir or pond. Think about each of these features. For instance, if you're purchasing a water right, you would want to take the time and effort to make certain that the person selling it actually owns the water rights and that they are transferred by deed, assignment, or decree using a title company or an attorney. Doing this vital research can save a lot of heartache and stress when purchasing a water right. Also be careful not to rely upon division records. The county recorder's office is the office of record for title ownership. Be on the lookout for and beware of trustees attached to water rights. Finally, if possible, it is always preferable to get a warranty deed for these types of transactions. If you are thinking about selling land, remember, water rights are pertinent to the land where they are used unless specifically reserved by deed. So if you are selling land that has water rights associated, be careful that you don't unintentionally convey the water rights by pertinence. Perhaps the most important feature of any water right is its priority date. Remember, water is distributed first in time, first in right. Priority dates are established by either the date of filing an application to appropriate or the date water was first put to use in the case of a diligence claim or underground water claim, or, as it is most often the case for senior rights, the priority date was set by decrees as early fights for water were settled by the courts. One important point to mention about priority dates and distribution of water is that groundwater rights are generally only regulated by priority in conjunction with the groundwater management plan. So the amount of water available for use under any particular right is limited by either the flow rate measured in cubic feet per second, the volume measured in acre feet, or both. For instance, some non-consumptive water rights for use in hydropower generation are defined only by a flow rate, while some groundwater rights are oftentimes only defined by the volume in acre feet. Most surface rights, however, are limited by both flow and volume. So, when we discuss flow and volume, just how much water are we talking? Well, 1 acre-foot of water is almost 326,000 gallons of water. That would cover an acre of ground, or just a little less than the size of a football field, to a depth of 1 foot. 1 CFS, or cubic foot per second, of water is equivalent to approximately 449 gallons per minute, flowing by the point of measurement. Another prominent feature of a water right is the point of diversion. This is defined as the place where the water is being pulled from, usually a natural hydrologic system, such as a stream or a well or a spring. The location of the point of diversion is specified by a survey description of the metes and bounds. The beneficial use of the water is the purpose to which the water is being diverted for and applied to use. Each use is quantified and becomes the defining and limiting element of the right. Irrigation is quantified in acres watered. Livestock watering would be the number of livestock drinking from the specified sources. Domestic is the number of homes connected to the source, which can be further refined into part-time or full-time residences. It could be the type of commercial or industrial use anticipated on the water right, such as power production. Finally, there is municipal use, which is a special kind of category with a public water supplier, such as a city or water conservancy district. The use of the water encompasses all possible uses served by that supplier, including all the aforementioned uses. It's kind of a catch-all and provides the greatest flexibility to the holder of this type of right. Another important consideration is how water rights are used together in groups. For example, you may have 3 water rights that together are approved to water 195 acres. The sole supply of each right would be the amount of use allowed under a particular water right. When used alone and separate from all other water rights in the group. For example, as you can see, water right 05-5000 would have a sole supply of 125 acres. 05-5123 would have 45 acres, and 05-5486 would have 25 acres for a total of 195 acres of irrigation. So how do we estimate the amount of water it takes to supply certain uses? Well, we use a term called duty. Duty is the estimate of the amount of water reasonably required for a specific purpose, such as irrigation or domestic use. For instance, for domestic use, we use a duty of 0.45 acre-foot per full-time resident, which is equivalent to about 400 gallons per day. If the water is for a cabin, or in other words, part-time use, we use a duty value of 0.25 acre-foot. Livestock duty is 0.028 acre-foot, or approximately 25 gallons per day per large animal, such as a horse or a cow. For irrigation, it really depends on where the land is located and what elevation it is at. Duty values for irrigation range from 3 acre-feet for high mountain valleys to 6 acre-feet in low elevation desert environments. Now let's talk about the difference between diversion and depletion. Diversion is the amount of water listed on the water right, measured either flow or volume. Depletion is not listed on the water right, but is an important consideration, especially when filing a change application. Both diversion and depletion can limit a water right, even for municipal uses. On change applications, both the diversion and depletion amount are considered. For example, a change application on 1,000 acre-feet of water in use for irrigation, which is generally about 50% consumptive, so the depletion would be about 500 acre-feet. If changed for use in a steam generation power plant, which consumes or depletes 100% of the water used, the right would then be limited by the depletion value to 500 acre-feet annually for power production. Finally, let's briefly touch on the process for obtaining water rights and researching water right records. To obtain a water right, you can file a new application to appropriate water in areas of the state that are still open to new appropriation. We have some areas like that in our southeastern region where all it takes is a new application and $150 to obtain a water right. Also, in some areas of the state, you can file a diligence claim to essentially make an existing use of water that began prior to 1903 part of the water right record. You can also file temporary applications to appropriate, good for 1 year, or, in the case of fixed-time applications, good for a period of time, like, say, 10 years before it expires. Finally, in areas of the state that are closed to new appropriations, you can purchase an existing water right or purchase ground with existing water rights attached to it from a willing seller. Please always remember that in Utah, water rights, in most cases, are pertinent to the land where they're being used. So if the seller does not reserve or keep the existing water rights in a land sale, then the water rights associated with the property transfer to the buyer by appurtenance. To update title to a purchased water right, the buyer would then need to notify our office after the deeds transferring title to the water rights have been recorded. The new owner would then need to provide copies of those deeds with the report of water right conveyance to our office to update the ownership records on the water right before you purchase a water right or file a new application with our office. We strongly recommend that you do some research. Our office has all the historical documentation on existing water rights and all the information on policies in the various parts of the state for filing new applications or change applications. When searching our computer database, please pay attention to the banner at the top of each water right page. It reads, "Warning, water rights make no claims as to the accuracy of the data." What that refers to is the fact that the official legal document defining the water right is the hard copy, certificate, water user's claim, diligence claim, decree, etc., found on the files of the state engineer, not the computerized database. There may be errors in the computerized database, so always check the hard copies on file, which are available either in the scanned documents, part of the computerized database, or the actual physical file located in our Salt Lake City office, with copies available in the regional offices around the state. Thank you for participating in our training today. That concludes our presentation on water right basics.